Good afternoon, everyone. Thanks for joining us today for today's Citizenship and Readoption webinar, part 2. This is a follow-up webinar that we offered last fall, and which is also recorded and can be viewed on our website. My name is Julia Norris, and I am Director of Affiliate Offices and Accreditation at America World Adoption. I'm going to introduce our presenter, Karen Law, in just a second, but first wanted to cover some housekeeping items. On the right side of your screen, you'll see a control panel, and there's a section called handouts. We have 2 handouts for you. You can review those during or after the webinar. There's also a section for questions, so you may type in any questions you may have for us, and there'll be a Q&A session at the end of the presentation, and we hope to be able to get to all your questions. So our presenter today is an adoption and immigration attorney practicing in the state of Virginia and a fellow of the American Academy of Adoption Attorneys. She represents adoptive parents and birth parents in private agency, international, step-parent, and relative adoptions. It's my pleasure to introduce Karen Law.
Well, thank you, Julia. It's a pleasure to be here. We had a really good response when we did this in the fall, and I think part of our impetus for revisiting this issue is that there were so many questions we didn't have a chance to get to. And so we've saved some of the ones from the fall, and we hope to use a lot of time today to answer new questions. So what we're going to start with is the new information, and then we're going to revisit the old information. So the new information applies to families, and I know America World works with quite a few of these people who are maybe with the State Department, or they're with some other government entity, not the military, but some other type of government entity, or perhaps they're working for a private company, they're living overseas, and they're adopting internationally. So let's just say the family is living in Malaysia and they're adopting from India, and they're a US family. And so in the past, and these are children who, once they're adopted, are going to, in the example I gave, will be living with their adoptive parents in Malaysia, not in the US. So the adopted children at the end of the immigration process are going to be staying with their US citizen parents in another foreign country other than the one they were born in. So what used to happen in a case like that was the adoptive family would have a home study done by a US agency, and they would complete either the I-600 process if the child was living in a non-Hague country, or they would complete the Hague process, the I-800 process, if the child was living in a Hague country. And it still is complex. They have to use, even though they're living in Malaysia, I'm just using that as an example, they would have to have a US-based agency do their home study. They would need to file the immigration I-600A or I-800A, depending, in the US, and then that would be approved, and they would complete the adoption. They would go to the embassy in the country where the child was living, and they would apply for either an IR3 or an IR4 visa. And then they would get the visa. They would bring the child to the US briefly, just for kind of a touchdown visit, maybe visit grandma or relatives, and they would apply for a US passport. And then once the child had the US passport, they would get the visa for Malaysia, whatever country they were living in, and then they would go back to Malaysia. And then typically what would happen is the certificate of citizenship would be mailed to them automatically to their US address. So this is how things have been done for many years, but as of 2017, all of a sudden, these families began getting alarming notices that in that case, that the child was not entitled to a U.S. passport and that it was revoked. And then they would get a letter from USCIS saying, we're not mailing you the certificate of citizenship because you aren't really living in the U.S. So technically, that's accurate. The technical thing is there really is a different track for citizenship for children who are residing outside the U.S. And there's a different procedure. It's just it really wasn't enforced in the past, might be a good way to say it. And so as far as I can tell, about the summer of 2017 or so, this is when it began being enforced. And so again, families who are in this boat would get a letter saying your child's passport was issued in error, it's revoked, please surrender it. And then they would also get a letter from USCIS saying, we're not mailing you the certificate of citizenship, your child isn't a citizen. So of course these families are really beside themselves and don't know what to do. The correct thing to do, and what USCIS and the Department of State are kind of working hand in glove, is they want you to use the correct pathway. So there's these families who are kind of caught in the middle, but going forward, they want you to do the correct pathway. And they're really, I've had 4 families, I think now, in that situation. I found USCIS and the Department of State to be very amenable to helping these families get this figured out. So let's say that you're not one of the ones caught in the middle. Let's say as of today, you're living in Malaysia and you're adopting a child from India. What would you do? Well, your agency would be aware of the change, and when it came time for the embassy appointment, the agency would be in contact with the embassy and let them know that this family is living in Malaysia, for example, and that they are going to need to follow a different process, the N600K process. And what they will work with the embassy on is that the family will apply not for an IR3, or actually in India it'd be IH3 visa, but instead they're going to actually be applying for a visitor's visa. And you say, well, gosh, they've gone to a lot of trouble to get a visitor's visa because they had to have the home study done and file the I-600A and all that background information. But some of the embassies are requiring the families to actually start as if they're applying for the IH3 visa, but add on top of that the DS-160, which is the form to apply for a visitor's visa. So some of those logistics are a little bit embassy specific, but essentially the family wants to be sure that in the Indian passport, it doesn't say IH3, it says visitor's visa. And then also, in my example, the family will need to get some kind of visa for Malaysia, right? Because this child has an Indian passport, they're going to be living with their family in Malaysia, they're going to need whatever is required to live in Malaysia. So those would be the 3 steps. Once they then leave the embassy with the child, they go back to Malaysia, the family will now apply, because they want this child to have U.S. citizenship, the family will complete the N600K form. And this is the correct form that is used when a child is obtaining citizenship and is living overseas with their U.S. citizen parents. So they apply using the N600K form. You might want to use an attorney for this. It's a little more complicated than some of the other forms. And it's actually filed in the US. You can ask for a particular office to go to once it's approved. And you might check with your attorney as to which office would be the best, because it's not always the one that's closest to you. I mean, I know that the wait times for some offices can be a year, and others it's much quicker. So you want to designate an office that will be a quicker time frame. So once the N600K is filed, then it's adjudicated by USCIS, and the family gets an interview notice saying, please bring the child to the US for the interview. The child comes to the US with their Indian passport and the visitor's visa is how the child gets into the US. And then they go to the interview, and at the interview, the child receives the certificate of citizenship. And the case that I had most recently, at the interview at USCIS, they actually handed the family the passport application. So the family was able to pretty all in one trip come in, do the interview, get the certificate of citizenship, apply for a passport, and then again they would need a visa for Malaysia in this case for the child in the US passport, and then they go back home again. So this is how it's supposed to work. There's an information sheet on the USCIS website. It's a little buried, but the date is September 21st, 2017, and that explains what you're supposed to do. Okay, so let's go back to the family who got the alarming email. By the way, you did this the wrong way. Your child's US passport is revoked. That's really alarming, as you can imagine. And so I've had a couple of those cases, and so they're each a little bit fact specific, but what you have to do is you do need to, the passport is revoked, so that's a done deal, and you do want to surrender the US passport. But the child is living in Malaysia. Often the visa for where the child is living right now with the US parents is in that US passport. So if the parents instantly, surrender the US passport, then the child is in Malaysia illegally, right? So what we need to do is make sure that the child's initial Indian passport is still valid and get a Malaysian visa in that Indian passport. So get the ducks in a row is one thing. And then you'll also want to surrender the US passport. In the letter that some of the families have received, it says to mail it to some address in the US, and I recommend against that. I think what you should do, and the two families that I've worked with recently did this, they made an appointment with their US at the embassy to surrender the US passport, and then they obtained proof that they had in fact surrendered the US passport. And again, they would apply this in the example I'm giving you. The family would apply for a Malaysian visa in the foreign passport, and also a US visitor's visa in the foreign passport. So the child has to have a way to get to the US. So that child is going to have a US visitor's visa in their foreign passport. And then you're going to file the N600K. Again, I would probably recommend you work with an attorney. You do need to explain why you did it the wrong way. And again, they're pretty forgiving on that because they know that in one of my cases, the embassy themselves told my family to do it this way. So it's not really that anybody's done anything wrong because this is how things were always done in the past. But the family needs to write an affidavit and explain, why did they do it this way, and submit that with the N600K. So they'll do that, and again, then the rest of it flows from there. Once the N600K is approved, the family will fly to the US with the child for the interview. They'll walk out with a certificate of citizenship. They'll apply for the US passport, and then if the child needs a visa to go back to Malaysia, they'll do that. Okay, so that's kind of complicated and doesn't apply to everyone. It just really applies to essentially expats. It does not apply, I should say, to US military. U.S. military is the one exception. U.S. military can do it the old way, but any other U.S. citizen who's living overseas has to follow this new process. Okay. So I don't have any other particular questions on this, but we certainly will look for those at the end. Here's one. This was a family that was adopting from India, and there was some back and forth with the embassy because the family was living in a foreign country and they were adopting an Indian child. And at first, the embassy told the family that they could not even come for the visa interview until the N600K had been filed and approved. And the problem with that is that's impossible, because you can't file an N600K until the child's actually living with you. And the child can't be living with you until you go to the embassy and get some kind of visa. So it's sort of a chicken and egg kind of thing. So once we explained that, then the embassy understood, and they were fine with an opinion letter from their attorney, which was me in this case, that I was planning to file an N600K. In fact, I think I may have even actually drafted the N600K and sent a copy of that to the embassy, so the embassy could see that, yes, there's a plan for this child to obtain citizenship, but technically it can't be filed until the child is living with their new family, and they understood that. Okay, let's see if there's some other questions about this particular topic. Julia?
Yes, we have a couple of questions. What happens if the child's U.S. visa, meaning the visitor visa, expires in the meantime?
It'll have to be renewed, but most visitors visas are 10-year multiple entry visitors visas. That's not usually a problem.
Okay, something happened to the second question. It disappeared.
Okay.
If anybody has any questions, though, please feel free to type them in and we'll try to get to them.
Yeah, so visitors visas are usually 10-year multiple entry, and then when the child comes for any particular stay with the visitor's visa, there's a stamp. It's usually a 6-month stamp, but you're not going to be coming until you have an interview anyway. Now, I did have one family who had done all this the right way. They came for a visit, and they were waiting for the interview here in the US, and we just really pleaded with the particular office to schedule the interview before the visitor's visa expired. But if that had expired, the child would have left and come back again. Maybe they'd go to Canada on a road trip or something and come back. But you want to be sure the child is here lawfully. Do we have another question, Julia?
Yes, actually, the question I was missing came back here. It's, if the process is different for U.S. military, how does USCIS know how to determine military applicants from non-military applicants?
They need to indicate that. I mean, it should be obvious from their address, honestly. It may not be, but when they have a home study done, the way they're catching this, maybe that's a good way to back up. How did they figure this out in 2017? What's happening is, when the family enters, they have all of their paperwork in that packet, and they hand it at the point of entry, and it goes to, I think it goes to Buffalo, to USCIS, and Buffalo looks at it, and if they look at the home study, and if the home study says, oh, this family is living in Malaysia, and they're not military, and they're working for the Red Cross or whatever the situation is, then that's what is now the red flag. So they're looking at the home study that was submitted as part of the I-600A or I-800A application, and they're also looking at whatever address you put on those forms. So a military family, they would have a home study done that would say that they're stationed at such and such Army base abroad, and they're in the military, and then their address, so it would be clear. And then also their ASP, when they're corresponding with embassy would say, you know, just to let you know, even though they're residing in Germany, they are a U.S. military family, so they will be applying for an IH3 or IR3, as the case may be.
Great. Okay. Another question. Although this is the proper process, many of the U.S. embassies abroad have no idea of this process and instead do issue the IR3 and IH3. Why are they unaware of this new process?
Well, I think it's just a lag in institutional knowledge, and that's why we're hoping to get the word out. I mean, it's completely true. The embassies are issuing those visas. The families are coming here, and they only find out later when they get the letter from the Department of State saying your child's passport has been revoked, that it was all done wrong. And then it's a mess to fix, which we just described. So the onus now is going to be on the agencies to be educated about this and the families. And if the embassy says apply for an IR3 or an IH3 visa, the family or the agency needs to push back and say, no, I'm living overseas with the child is, we need to follow the N600K process. It's an education piece that needs to be done.
Okay. What happens if an expat family received an immigrant visa already? Do they just file the N600K as soon as possible?
Well, it depends on the situation. I mean, have they come to the U.S. yet or not? If that's hard, I think I would try to undo it. I would think I would try to go back to, let's say they got an IR3 visa, let's say, and then they went to, or IH3 visa mistakenly, and then they took the child back to their home in Malaysia, and they're waiting for the summer to bring the child here. And we know how this is going to unfold now. So there should be a way for the child to, they're going to have to work with the embassy to explain that this was issued in error and that the child needs actually a visitor's visa and the child is applying for the N600K. So there's definitely going to need to be some back and forth. And that may be something you need to get an attorney involved in. You know, they're very willing to help you, but it's an education piece. Anything else, Julia?
Yeah, we have quite a few. I'm trying to read through them all, but let me go ahead and choose one here. This is just similar to the other question about the military, active military. If the family is not active military but is employed through Department of Defense, would their process be the same as military or the expat family?
I think they're the expat family. I think you have to be active duty military to get the exception.
Okay. Let's see.
Most of the families I've worked with work for NGOs or the Department of State. But the active duty military can do it the old way.
Okay. What about this? Many U.S. citizens living abroad are still getting the IR3 and IH3 visa to return to the U.S. Then they are making an in-person appointment at a USCIS office to file their N600K. Can this also be an option for families?
No, the N600K has to be filed through the lockbox. If you go to the uscis.gov and click on forms and then look at N600K, it has to be filed through the lockbox in Phoenix, and then it's routed to the particular local office where you want the interview, and it's usually a 5-month wait. So you do not want that child to enter the US on an IR3 or IH3 visa, and I'll tell you why. If you do that, the child, it's confusing, but the child actually becomes a lawful permanent resident, not a US citizen. And so they're not a citizen, they're a lawful permanent resident. I had this happen with 2 of my families. And so they came not knowing, they got the passport, then they got the letter revoking the passport, but in USCIS's eyes, because they entered with that IR3 or IH3 visa, they're considered a lawful permanent resident. Then they leave. If they leave, they don't have a lawful permanent resident card and they have no way to re-enter the US. And if they apply for a visitor's visa, they can't get a visitor's visa because they're a lawful permanent resident. They actually have to file a different form, which is called the I-407, to surrender their lawful permanent resident status, even though they don't have a card, and then apply for a visitor's visa. So basically, the onus is on and the agencies now to go back and get those visitors visas, and do not come here, do not bring that child here on an IR3 or IH3 visa.
Okay, what about this? We have a family who's currently living abroad, but will move back to the US once their adoption is finalized in the foreign country. How should the family proceed with getting the child's certificate of citizenship?
Mm-hmm. Well, if they can prove they're moving back, they can follow the old route, okay? And that family would need, for example, because see, their home study is going to be done as if they were living overseas, and their address is going to be an overseas address. So that's going to be a red flag. So what they're going to have to do is prove to USCIS and the Department of State that in fact they are moving back to the US. And that I think would be done when you file for the visa, not pretty like the visa, but at some point you've got to alert them to that through perhaps a job offer letter at your new location in the US. But there's got to be something on paper that indicates the plan to move back to the US with the child.
Okay, thanks. What about some countries consider the foreign passport as expired as soon as the adoption is final. Is that correct?
Yeah, that's very tricky. For example, China. So that's why you do not want to get a US passport. If you did it the wrong way and you came to the US, got your child a US passport, the child's Chinese passport would no longer be valid because Chinese law doesn't recognize, as I understand it, dual citizenship. So then you're in a mess. So again, you want to avoid that by not coming here on an IH3 or IR3 visa and getting a US passport. Now, in terms of does the child lose their citizenship just by virtue of the adoption? I would argue the answer to that is no, because if the child is not yet a US citizen because they haven't filed the N600K, they're just a visitor in the US, they have to be a citizen of some country. So I would say that the child would still be not, that the defining point where the child changes from one to the other would be when the child obtains US citizenship, which would be after the N600K is approved and the child comes to the US. That could be a bit of a negotiation, and it may also depend on the laws of the country.
Great.
Julia, I feel like, is there another one, or perhaps we should move on to the next category?
Sure, let's move on so we don't run out of time.
Okay. So now we're going to talk about the more common scenario, which is children who are going to be living inside the U.S. option. That's, the majority of the families will fit into that category. And the questions that I've seen, typically, I think people nowadays, it's a pretty smooth process, but a lot of the questions relate more to especially the 2001 to 2004 time frame. That seems to be the very confusing time frame. And so the general rule for a child who's already here and you're trying to figure out, is this child a citizen or not, is you would look in the child's original foreign passport and look at the visa stamp. And the little kind of slogan Ends in 3, you are free. Ends in 4, there is more. So what that means is an IR3, an IH3, that child, when they landed in the US, became a US citizen. Ends in 4, there is more. What that means is when the child landed in the US, they are not a US citizen, they are a lawful permanent resident. And there is more means that under US immigration law, the Child Citizenship Act, the family that adopted them was required to do a readoption or finalization in wherever they're living before the child's 18th birthday. So that's why there is more. In other words, there's an additional process that's required for the child to become a US citizen under the Child Citizenship Act of 2000. So remember, I was telling you the tricky area is the 2000 to 2004 area. And why is that? Okay, so the Child Citizenship Act was passed in 2000, but it became effective February 27th, 2001. And for that time frame, February 27th, 2001 to February of 2004, children who did the normal process and then they came home with their families and they landed in the US, they did not receive a certificate of citizenship. Instead, they received a lawful permanent resident card, which is very confusing because typically a lawful permanent resident card means you are not a citizen. But the lawful permanent resident card that these kids received, it wouldn't have been an IH because we didn't have Hague adoptions. It would be an IR3 visa at that point. Anyway, the lawful permanent resident cards that these children received, if you look at the card, it says IR3. And you know that means citizen. So isn't that confusing? They have a lawful permanent resident card, but the little numbers and letters mean I'm a citizen. And the thing that's even worse is usually the family came home with the child, started doing life, and felt like they were done. They probably heard something about this Child Citizenship Act, and they thought, oh, I adopted this child. My child's surely a citizen, and they didn't think much about it. And where it comes up is then, and I got a rash of these contacts recently, usually it comes up when they take the child to get a driver's license or a permit, because at the driver's license facility, they will always ask post 9/11 for proof that you have lawful status here in the US. And the family's like frantically looking through everything and they find this little card. Well, the card was only good for 10 years, so it's expired. So the child has nothing. It looks like the child is actually undocumented. And that's, very frightening to the family. Can my child be deported? Are they sending this child back to Russia, et cetera, et cetera? So that's the problem. Now, if that happens, and that happens a lot, the child, let's say that the card has, let's talk about two possibilities. Let's say that the card has expired and it says IR3. In that case, again, we know the child is a citizen. What that child should do is apply for a certificate of citizenship right away, but that's a year. They could also go ahead and apply for a US passport, which is a quicker time frame, and they might get a passport even if they don't have a certificate of citizenship. It's a little bit, there's a little bit you have to explain because the lawful permanent resident card normally means you're not a citizen. But if you can get maybe your senator or congressperson involved, if you can explain to them, they should be able to look it up and know what an IR3 visa means, that this child is a citizen. Okay, so what if the child is not a citizen? and you can look at the card and it says IR4 visa. If the child is under 18, then you can go ahead and adopt the child in your state of residence. One question I get is, well, I was living in New York when I brought, the child from Ivan home from Russia, and now I live in Virginia. It doesn't matter where you first landed. You can readopt the child in Virginia now that you live here, and you just have to follow whatever the laws are for readoption in your state of residence. But you have to complete that readoption before the child turns 18. So inevitably, the family, for whatever reasons, didn't go to the DMV, the driver's license facility, when the child was 16. Maybe this child just really wasn't interested in driving, whatever. And they don't go, and it's too late. The child's already 18. And I certainly had some of those cases. So what do you do then? Well, what I should explain, I think I have this somewhere. Okay, so what I should explain is there is a difference between proof of U.S. citizenship and status of U.S. citizen, and the same thing is true for lawful permanent residence. So if the child is a lawful permanent resident, so they have that little card, it's expired, it said IR4, and they're over 18. What does that mean? They're not a citizen. They are still a lawful permanent resident, even though their card has expired. It's kind of like, let's say you're married and you don't have your marriage license with you. Well, you were married lawfully and you did have a marriage license. You've lost that paperwork. It's the same thing. The child is still a lawful permanent resident, but their card has expired. So what that child is going to need to do is reapply for a lawful permanent resident card. All right, and that is a Form I-90, and it takes, you can look that up, but I think it takes about 6 months now. It's not a quick process. There's, another question I often get asked is, well, why would I need to apply for citizenship? I already have, I have a birth certificate from Virginia or wherever. I did, I never obtained that N600. I never filed the N600. I never obtained the U.S. Certificate of Citizenship. Isn't my child's readoption and Virginia birth certificate good enough? No. There's only 2 forms of proof that for these kids that you are a U.S. citizen, either a certificate of citizenship or a passport. So the Virginia birth certificate, which is usually called the certificate of foreign birth, a social security card, the lawful permanent resident card, all of those are not proof of U.S. citizenship. And I also often get asked, why should I spend the money on a U.S. certificate of citizenship if a passport will do? Which is a great question, especially since they raised the cost so much of the certificate of citizenship recently. But I still think you should do it for a couple reasons, because if you don't and you apply for a passport, it's going to expire and you're going to forget to renew it, and then you're going to have nothing. Whereas a certificate of citizenship is a forever document. That's one reason. And then the other thing is sometimes children who when they grow up are working for the federal government in particular, the federal government really does want that certificate of citizenship. Okay, so let's move to a different topic. Let's suppose that you had a plain vanilla case. You adopted a child from China, and you brought the child home, and it was after 2004. You have a certificate of citizenship, but there's a problem. Maybe that you did a readoption and you changed the child's name. So the child's name now is different than it was on the certificate of citizenship. Or maybe, let's say you adopted a child and after you got home, it became obvious that the child's date of birth was really incorrect. And that's not uncommon in some countries in particular. So maybe you went through the readoption process in your state and you changed the child's date of birth. You probably had to have medical evidence, and you got a birth certificate from your state saying this is the child's new birth date. But in USCIS records, and on the certificate of citizenship, it has the other birth date. And probably the child's social security card has the other birth date. So what should you do? Well, if it's their error, like maybe they misspelled a child's name or something, you can actually for free file the form N565, send it in, follow the instructions, and you will get a new one without paying anything. But if it's the case like I was describing where you think the date of birth is wrong, then you would have to readopt and get the date of birth changed in the state court, and you would need to file the same form, the N565, get a new certificate of citizenship with the corrected date of birth, and you would need to go to the Social Security office and also be sure that the date of birth is changed in that database, and that's really important. So let me just read you a question that I got on May 15th. Hi, Karen. I was given your name by another attorney. I have two students that need help with getting their paperwork in order. They are sisters, high school seniors who are estranged from their adoptive parents. They're both heading to college and they're having lots of issues because they just realized they have two different birthdays. One is on their US birth certificate, and one is the birthday they were given from the orphanage abroad. Apparently, the foreign birth date is linked to their Social Security number. Anyway, they cannot apply for college and they've hit all kinds of roadblocks. What should we do? So the answer to that question is that these girls, hopefully there's a court order that they have access to that changed their date of birth along with the birth certificate that has the new date of birth. They need to file this N565 and get the date of birth changed by USCIS, and they need to go to Social Security and change the date of birth. Now, this is a problem time-wise because these kids are going to college pretty soon, it sounds like, and an N565 is usually about a 3-month process, if not longer. What they could try to do, we have something called the Accuracy for Adoptees Act, and that was passed, I believe, in 2014, I want to say. The group that I'm a part of, the American Academy of Adoption Attorneys, was instrumental in getting that passed. But in any event, that is federal legislation which says that every federal agency has to recognize a changed date of birth if the date of birth is changed through the state process. So technically, these girls could go directly to the Social Security office with their new date of birth and a copy of the Accuracy for Adoptees Act, and probably have to talk to a supervisor and then another supervisor, and it should be changed in the Social Security database without getting the N565. We found Social Security offices are resistant to that, but that federal legislation, they're supposed to do that. Okay. We talked about this a little bit already. What if it's too late to adopt the child? She's older than 18. She's got an IR4, her expired. Well, that child, like I said, there's a difference between status and proof of status. She is still a lawful permanent resident, but she needs proof of that. So she should apply to get a new green card. It's called an I-90 is the form. And that would get her her new green card, but it's not quick. It's going to take a while. And the other thing she might consider is applying to become a U.S. citizen. So what do I mean by that? What we've been talking about so far are children who are citizens under the Child Citizenship Act automatically if they fulfill certain conditions. There's a different process for adults called the N-400 process. And that's the process that any adult uses to become a citizen. The form is the N-400 form. They have to have been a lawful permanent resident for at least 5 years. They have to have lived in the US for more than half of that time. They have to be able to pass a simple English test and a pretty easy civics test. And there's sample questions on uscis.gov. So if they can do all that, then they are probably going to want to apply to become a citizen. The only danger with that is if they have had some kind of criminal history. That can be a problem, and there is a danger of deportation in that case. In other words, if a child who has some kind of criminal history that's significant applied to become a citizen, that would be discovered, and they might actually be sent back to Korea or Russia or somewhere like that, which would not be good because they don't speak the language and they have no ties there. So that is something, some of children are better off never applying to become citizens and just hoping that they can keep their green card status. It's going to be a little fact specific and they should talk to an attorney. And you may have read in the news, there is a group of kids who were adopted. I believe they were adopted, many of them from Korea. And they were lawful permanent residents. Their families never readopted them. They did commit some kind of deportable offense and they were deported. So this is not, you can Google that. There's some pretty bad situations involved in that. There is a potential fix to this, which I want to talk up. It doesn't help kids who have significant criminal history, but it does help other kids who are IR4s and who were never readopted. And it is Senate Bill 2522, and the companion bill is HR 5233. And that bill would give automatic citizenship to older adoptees who have not had significant criminal offenses. So that's something that we think is important and hope that you will support. Okay, so let's look at some questions. I have one more, and then Julie, I'll turn it over to you. Here's a good question. I have two actually. Okay, so here's one. Hi Karen, I escorted a child from Albania to Chicago back in the 80s. The family had several other children and no time to travel abroad. The child came in on an IR4 visa because the parents did not see her before the adoption and I was the escort. Her adoptive mother called me recently and said her daughter's getting married and is planning to go overseas on her honeymoon. In applying for a passport, she found out that she was not a citizen because her parents did not readopt her in Illinois. They didn't think they needed to. They were able to obtain a social security card, etc., but when she applied for a passport, she learned of her status. So this girl is 29. What advice do you have? Well, this is kind of a classic example of the situation which would be fixed by the new legislation, S2522 and HR 5233, because this is someone who did not become an automatic citizen. Back in the 80s, that was even before the Child Citizenship Act, and the law back then would have required both of the parents to proactively file a form, which was at the time, I believe, the N643, to make the child a citizen, and they didn't do it because again, families are well-meaning usually. They just don't know that they need to do this. So the new legislation would fix this. But this child, or now adult, young adult, she is a lawful permanent resident, even though her lawful permanent resident card, I'm sure, has long expired. And so what she could do in the short run, she could apply for a replacement lawful permanent resident card using the I-90. And depending on the wait time, and if she has no criminal history, she might want to apply to become a U.S. citizen like any other adult using that N400 process. So it's going to depend on the wait times. It sounds like she needs to probably plan on a U.S. honeymoon, though. Okay, here's another one. Dear Ms. Law, I recently attended your seminar with America World. We adopted our daughter, Faith, in 2004 from China. We recently learned that we do not have a certificate of citizenship and never had one. Trying to find out if we were ever issued one, I contacted immigration and was told to complete a FOIA request. I did. The reply was there was not enough information. My question is, what do I do now? Her Chinese passport has an IR3 stamp, and we have not gotten a US passport either. Okay, so this, based on the IR3 stamp and the timing, if the child came in 2004, depends on when in 2004, but let's say the child, and in this case, this is truly what happened, this Faith came to the US in October of 2004. So as of February 2004, they really were sending certificates of citizenship to these families. So Faith really should have received a certificate of citizenship. It later turned out that the family kind of moved in the middle. And so what they did was they did an info pass appointment, and you can do that at your local USCIS office. You go to uscis.gov and click on info pass appointment. So she and Faith went in, and the officer looked it up and found out, yes, you were issued a certificate of citizenship and it was mailed out. Well, she never got it. So what she needs to do is file the N565 for a replacement certificate of citizenship. And one of the categories is I lost my certificate of citizenship. So that's what the family's going to do. Okay, Julia, do we have some other questions?
Yes, we do. What happens for U.S. citizens residing abroad who adopt a child, receive a visitor's visa for their child to enter the U.S., and then are denied the certificate of citizenship? Does that actually happen?
No. Not if they, unless they just, yeah, I mean, there's certainly criteria for an N600K, but look at the form and it tells you what they are. It's a little difficult to understand, but essentially the U.S. citizen parent has to have lived in the U.S. for 5 years, I think it is, 2 of which were after the age of 14. So that's a requirement to use the N600K process. So if that weren't true, you could be denied, sure. But usually what we do is get the U.S. citizen parents' high school and college transcripts, and they were living in the U.S. during those times. And then, it's not honestly the easiest form to fill out. You might want to hire an attorney to do it, but the instructions are the go-to place for more information.
Okay. So along the same lines of families living abroad, there's another question. Let me read it. I'd like to revisit the N600K process for just a second. I have a family living in Uganda right now. They asked about this and were told by the U.S. Embassy to file the I-600 so that they can qualify the child as a family member, and that this is separate from the visa process. After filing the I-600, they would then file the DS-160. Is this correct, or should I have the family pushed back again?
No, that's the right process. Those are the right forms. So what the family's doing is they're filing, they're using the orphan process, which is the I-600 process, and the DS-160 is the form that's used for a visitor's visa. So the embassy is telling them the right thing to do. And then after that, they get the DS-160 approved, which will be the visitor's visa and the Ugandan passport, then they will file the N-600K. Then they'll get the interview and they'll bring the child to the US.
Okay, great. What if your state does not allow for readoption, but you need to go through that process for citizenship, like Michigan, for example?
Great question. And there are some states, so I sort of oversimplified by just saying you have to do a readoption. There are some states, there's a really good resource through the Child Information Gateway that looks at the different laws in each of the state on readoption, and it's not completely up to date, but it's a good starting point. So if your state does not have a readoption process, then what you do when you file the N-600 form for your child to become a US citizen, you attach a copy of the Michigan law that says we recognize the validity of this foreign adoption without a readoption. That's probably what the Michigan law says. So basically, you just proactively, when you're filing your form, prove that your particular state does not have a readoption process. So there's nothing you could do, and they will honor that.
Okay. How about this one? This is another good one. What if a family came home with an IH-4 visa and readopted, but waited years to file an N-600? Now the family cannot recall ever receiving an LPR card for their child, and the information on the card is needed for the N-600 application. The child is still a minor. Can the family file a replacement LPR card and then complete the N-600?
I wouldn't do that. I've had that happen many times. You don't really need the card itself for the N-600. They do ask you for the child's A number on the N-600 form, but the A number is also in the child's foreign passport. So if you look in the foreign passport, where the stamp is, you'll see the A number, and you do need that number. That's like the it's like the equivalent of a social for USCIS. So you need that, and you'll also need in the foreign passport, it'll tell you the date the child entered. You probably remember what airport the child went through customs at. So I've actually had that happen quite a few times. And then you just say with your N-600, you say, we've lost the actual lawful permanent resident card. But the other thing they can do, if they go to, I think it's cbp.gov, there is, I'm pretty sure that's it. They can look up, you can look up your child's travel history. So if you have your child's foreign passport, right, you can go to cbp.gov, and what'll pop up on your home screen is get my travel history. And then you have to put in the child's name when they came to the US and the child's foreign passport number, and it'll pop up with when the child first came to the US, the exact date. It's called the I-94 form. So you can pull that up too as additional proof that the child has entered the US as an IR4 back in the day, and then you're also going to have to, of course, submit the adoption decree. Kind of a related question that I get, Julia, is, okay, I had an IR4 child, I did the readoption before the child turned 18, but the child is now 19. Is it too late? And the answer to that is no. The child has to qualify before they're 18, but you can file the actual form, the N-600 form, after the child turns 18.
Okay, great. I have another really good question. Let's see. Lately, families are receiving their child's certificate of citizenship with the child's original name and AKA their new name. Should the family file an N565 after readoption, or is the also known as name okay?
Yeah, that's a really good question. I've been seeing that a lot because to me, what that looks like is the child's name is John Smith, also known as like both names, which isn't accurate. But I think in reality, that is proof that either name is acceptable. So as long as one of those names is the child's original name, I think they're okay. They would not need to do the 565.
Okay. Could you repeat the website again for those that needed to write that down to find that travel information you just mentioned?
Yeah, I think it's CBP, C as in Charlie, B as in boy, P as in Paul, .gov.
Okay. Let's see, do we have time for another question?
I'm fine with that if you
Okay.
are.
Yes. Let's see, this is a little long. I'm going to read it. How long may it take for an expat who has adopted a child abroad to get an in-person appointment with a USCIS office to apply for the certificate of citizenship? Some countries will not allow an adopted child to enter their parents' country of residence on a passport from a particular country. For example, Mexico will not provide a visa to a child adopted from China to enter Mexico. So the family will need to return to the US first and get the child's certificate of citizenship and then US passport before they can enter Mexico with their adopted child on the child's US passport.
Okay, so if I'm understanding this correctly, are they saying like, let's suppose the family lives in Mexico, they adopt a child from India, let's say. Are they saying that the child could not obtain a visa to live with the American family in Mexico in their Indian passport?
Yes, that's what she's saying.
Yeah, I don't know. I mean, I don't know what the laws of Mexico are, but as far as length of time, that is that's an issue because to file the N600K, excuse me, the child is supposed to be like a prerequisite is that they're residing abroad with their US citizen parent to even file the form. So they would have to complete the form and be living with their parent overseas. I suppose if one of the parents had some flexibility, they could stay with the child in India, and the day after they get the visitor's visa, file the N600K. You can't make an appointment and file it in person. You have to file it in the US at the Phoenix lockbox. And I would try to find out the quickest office. But the quickest I've seen is 2 to 5 months. 2 months is rocket speed, 5 months is normal. So that's a pretty long time to hang out in India before you go back to Mexico. That's a tough situation.
Yeah. Okay, we have some questions that we didn't get to in the first part of the webinar, so I'm going to real quick go through that because that's, I think, the main focus of today's webinar. Here's one from Lisa. I'm a bit confused on the process between obtaining the visitor's visa and returning to country. If the child receives a visitor visa for the US, could they not just stay in Malaysia, file the N600K, and wait for their appointment? Why would they need to actually travel to the US on the visitor visa?
Now, that's exactly what they should do. That's what they should do. They should, when they're in India, they should get the visitor's visa for the US, but they shouldn't go to the US right away. They should go to Malaysia and live there until the N600K is adjudicated and they get that invitation 5 months later to come to the US.
For the appointment, okay.
Mm-hmm.
Okay, let's see. I think this was addressed, but let me just read it again. If we have a family that's living on a US military base overseas, but is only a contract worker, not military, do they do it the new way or the old way?
I think they have to do it the new way because they're not active duty.
Okay.
That you can also tell, though, you can double check that. Look at the form, N600K form, and look at the information, you know, the instructions, and it clarifies that.
Okay, let's see. I don't think I've read this one. If a child is adopted by a U.S. citizen living abroad and it's not possible to get a visa for that child to enter the adoptive parent's country of temporary resident, what options do the family have?
Well, I think that was the earlier question that we asked. I can't imagine that happens that often. So I don't know the answer to that, but that is a question of, you know, sovereignty. The country, like say Malaysia, certainly has control over whether they give a visa to an Indian child to live there or not. But I personally have not seen that to be an issue. Let me put it that way.
Okay. All right, so that's the end of my list. Unless I've missed anything, please quickly type in a question for us. I don't have any additional ones unless I missed one.
Okay, well, in that case, I just say that I know that I'm happy to be a resource for agencies and families and America World as well. And some of this is tricky, like we said, that especially the kids that were adopted between 2001 and 2004 are very confused about what their status is, and the difference between proof of status and having the actual status is an issue. And then there's this disconnect between, for kids living overseas, between the new way and the old way. But if we're able to help you, we're happy to do that. And anything else on your end, Julia?
Just want to let everybody know that a recorded version of today's webinar will be made available for all registrants that provided their email address, which I think is required. You will receive that probably within like 24 hours. You'll receive that copy of the recorded version in an email, as well as we'll try to include the handouts in case you couldn't print those. And I think that's all I have.
Great. Well, thank you very much for spending this afternoon with us.
Yeah, thank you very much for joining us. And thank you, Karen.
My pleasure.